according to Companies Act 2013. Okay, so there must be a prior notice that it should be given while conduction of meeting, that is 21 days early. So when it comes in terms of a directors meeting, there is no provision for a members, that is the shareholders of the company. It is a shareholders meeting, okay, that has been conducted for the welfare, for the benefit of the shareholders, to maintain the transparency for shareholders. Among the board of directors, there are certain committees that has been formulated according to Companies Act 2013. Hello everyone, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First State College, MYSURU, the Temple of Excellence. In today's session, we are going with the subject called Company Law and Practice. It's all about session 1 of Unit 4. It's about company meeting. Here in today's session, we are going with what exactly the concept of meeting is, why the meeting is required for the company. Okay, so this is agenda of today's session. We are going with the concept of meeting. As I said, types of company meetings. So which are the types of company meeting that is being conducted in the companies according to Companies Act 2013? Importance of a company meeting. Okay, so why we give importance to the company meeting? What is the importance or the role that is played by a company meeting? Role of company secretary in conveying the meeting. So as I explained in the previous session, that is Unit 3, Session 4. Okay, so this company secretary plays a vital role when it comes in terms of conduction of a company meeting. So what is the role that is being played by a company secretary? What are the responsibilities in terms of a company meeting when it comes in terms of company secretary? These are the topics that we need to cover in today's session. Moving forward, meaning of a meeting. So what exactly the meeting is? Okay, so when it comes in terms of a meeting, okay, so a common sense. Okay, so a single person cannot conduct a meeting. There must be presence of 2 or more member. Okay, there must be an agenda of the meeting. Okay, so there must be a matters should be discussed. Okay, so that we call it as a meeting. Okay, so basically when it comes in terms of a company meeting, okay, so there must be a criteria for the conduction of meeting. There is a protocol for the conduction of meeting under Companies Act 2013. There is a quorum under the Companies Act 2013. Okay, so there are certain various criteria that we need to consider for the conduction of meeting. But here, when it comes in terms of a meeting, it is a just basic meaning of a meeting according to the Companies Act. Okay, so the context of the meeting, okay, so implies with the coming together certain number of members. Means there are certain number of people who are coming together. So they are coming together for the conduction of meeting. So in that meeting, they are going to take certain decisions. In terms of meeting, they are going to make certain decisions. They are going to sort out certain problems. They are going to disclose certain financial statements. They are going to bring the solution for the problem. Okay, that is the main reason for the conduction of meeting, for transferring the business in agenda. Okay, see, whatever the meeting that they are going to conduct in terms of organization, the agenda should be prepared about a meeting. Who is going to prepare agenda? Company secretary is responsible for preparation of agenda. They are going to list out the topics which is yet to be discussed in the meeting. If there is any kind of a errors, if there is any kind of a problems, if there is any kind of a decision should be taken, if there is any kind of the thing should be updated. Okay, so that should be the agenda, for which provides notice has been given. Okay, so here it is a obligation of the organization to send the notice for the relevant parties who are attending a meeting. Okay, so what happened? Okay, so they must send the notice, okay, 21 days priorly. 21 days priorly, they are supposed to send the notice for the relevant parties. For example, it may be the shareholders, it may be the directors. Okay, so it may be the creditors. Okay, so they must conduct a meeting. Means they are supposed to send a notice, prior notice, before they conduct the meeting. And after that, okay, so as I said, there must be minimum of 2 parties should be present to consider as a valid meeting. Okay, so here it is going to say that there must be 2 or more persons. Okay, a single person cannot discuss by himself. He cannot make the decision by himself. It is a group of association. Okay, so it is a association of people. Okay, so that they are going to take the decision means there must be presence of 2 or more members. Okay, so the purpose of the meeting is consider the issues. If there is any kind of the issues, if there is any kind of the problem, if there is any kind of the conflict, they need to take relevant decisions. They need to discuss about that particular topic. with each other and finally come to the conclusion. And also, it may be a common interactions regarding the transparency, regarding the financial statements, regarding the decisions, regarding taking the opinion of the individual people regarding the particular decision of the organization. Okay, that we call it as a basic introduction about the meaning. And if I want to say a meeting in a single word, okay, so meeting is essential when it comes in terms of a company according to Companies Act 2013. Okay, so meeting is conducted to maintain the transparency and to create the awareness about the particular task or the thing, and also to gain the trust of the people, whether it is a stakeholders, whether it is a creditors, whether it is a shareholders, whether it is a directors, so that they can maintain transparency, discuss with each other, and finally come for a conclusion. Okay, so it is a way how all the peoples are brought together for the discussion of a given topic. Okay, that we call it as a meeting. Types of a company meeting. When it comes in terms of a types of company meeting, this company meeting is been divided into 4 categories. One is members meeting. It is all about shareholders meeting. Members meeting is nothing but shareholders meeting, followed by directors meeting. Okay, so when it comes in terms of a directors meeting, there is no provision for a members, that is a shareholders of the company. Okay, so only the directors can attend the meeting, not the members. But top level management have all the authority to attend this meeting, directors meeting, but not the shareholders. So the third type of meeting is creditors meeting. So it is a meeting of a creditor when it comes in terms of a insolvency. If there is any kind of a insolvency that is being faced by the organization, then they are going to conduct this kind of a meeting to divide this thing. Final meeting of dissolution. Okay, so dissolution is nothing but the liquidation. Okay, so it is a meeting that is being conducted by the organization. Okay, when the organization get dissolved, the organization get liquidated. Okay, so that is the last meeting of the organization. When it comes in terms of a members meeting, I said it is a shareholders meeting. Okay, that has been conducted for the welfare, for the benefit of the shareholders, to maintain the transparency for shareholders. Okay, so when it comes in terms of a shareholders meeting, firstly annual general meeting, AGM, that we call it as annual general meeting. The name itself, it is going to say that. Okay, so once in a year this kind of meeting will be conducted when it comes in terms of organization. Okay, from the commencement of business, there is 18 months of time to conduct first annual general meeting according to Companies Act 2013. I repeat, from the day of commencement of business, there are 18 months of time for the conduction of first annual general meeting. And the difference between first annual general meeting and second annual general meeting will be less than 15 months. Within 15 months, okay, so they must conduct annual general meeting. Okay, so within the gap of 15 months, they are supposed to conduct a annual general meeting, followed by extraordinary general meeting. Extraordinary general meeting, see, when it comes in terms of an annual general meeting, we are going to discuss about the financial statement. Okay, so where shareholders are present in annual general meeting, all the directors are present in the annual general meeting, followed by all the top level management people. Okay, chief officers are present in the annual general meeting. What exactly they are going to discuss? They are going to discuss about the financial statements, profit or losses that is made by the organization. Okay, they are going to discuss about the distribution of dividend. What is the percentage of dividend that they can allot? Okay, if there is any queries regarding the allotment of dividend or profits and losses of the organization, income and expenditure of the organization, the shareholders will be having all the rights to pitch a question for the directors of the organization so that they can clarify their doubts. Okay, it's all about annual general meeting. Okay, in annual general meeting, all the terms and conditions will be discussed about the profit that is made by the organization, how exactly they are going to share the profit, what is the dividend ratio that they are going to share towards the shareholders. Okay, and in the same way, the shareholders also having a right to pitch a question and also to have a right to vote the particular designation, whether it is a managing director, whether it is an auditor. Okay, they have complete right to select the individual people or the board of members, followed by extraordinary general meeting. This extraordinary general meeting is a kind of a special meeting that has been conducted by the organization in terms of emergency situation. in any kind of a emergency condition may get arised in the organization, they cannot wait till the annual general meeting 1 year of time. Okay, so they are going with the extraordinary general meeting. Okay, they are going with what? Extraordinary general meeting. Okay, immediately they can conduct a meeting, but 21 days priorly they need to send the notice for the relevant people who need to attend the meeting. Okay, here all the meeting 21 days earlier itself they are supposed to send the notice for the people to attend the meeting. Okay, without fail. Okay, so here also they are supposed to send the notice, but immediately that they are going to conduct a meeting, that we call it as an extraordinary general meeting. Statutory meetings. Okay, statutory meeting is a special kind of a meeting that is being conducted only once in a lifetime of the company. The company had started, within few months only they are supposed to conduct this statutory meeting according to Companies Act 2013. Okay, so in that statutory meeting they are going to disclose all the information regarding the investment of the organization, expected profits of the organization, plans, visions, missions, goals of the organization. All the things will be disclosed to the shareholders when it comes in terms of a statutory meeting. Class meeting is a group of people who are going to attend the meeting. For example, when it comes in terms of a shareholder, there are some equity shareholder, okay, one who are inside the organization. There are some preference shareholder, one who are outside the organization. Separately for one group of people that they are going to conduct a meeting, either it is a equity shareholder or preference shareholder, or they are debenture holder or creditors. They are going to conduct a meeting, that we call it as a class meeting. For a separate group of people, they are going to conduct a meeting, that we call it as a class meeting. Directors meeting. When it comes in terms of a directors meeting, as I gave you the example previously, okay, so directors are liable for this meeting. Okay, they need to attend this meeting. Okay, all the kinds of the major decisions of the organization will be decided or taken in this directors meeting. Okay, so when it comes in terms of a directors meeting, board of directors meeting and committee meeting. Okay, there are two kinds of meeting under directors meeting. Board of directors meeting. Okay, so board of directors meeting will be conducted 4 times a year. Okay, 4 times per annum. Okay, so they are going to conduct a directors meeting quarterly. Once the incorporation happen in a company, within 30 days they need to conduct this board of directors meeting. All the relevant decisions, all the changes which have to be happen. Okay, if there is any kind of a extinction, if there is any problem, okay, all the things should be decided. Okay, in this board of directors meeting, there is a provision for top level management to attend this meeting. When it comes in terms of a committee meeting, among the board of directors, there are certain committees that is been formulated according to Companies Act 2013. For example, okay, 12 directors in the organization, let me say. These 12 directors, say for example, there are 12 directors in the organization. These 12 directors have been classified into 3 categories. Okay, so there are 3 committees. Okay, so there are more than 3 committees in the organization. Say for example, I am giving the example. Okay, so here, this is the auditing committee. So this is a counseling committee. This is a performance appraisal committee. Okay, so these are the different committees that is present in the organization. Okay, these directors are been divided into committees. Okay, so based on the, for example, there is an audit committee. Okay, if there is any kind of audit related things, should be discussed with the audit committee members. Okay, other related things with the other committee members. Based on this, that they are going to discuss the things that we call it as a committee meeting. This directors is been classified into different committees based on the speciality of the meeting that they are going to conduct separately. The meeting that we call it as a committee meeting, followed by board of directors meeting. In board of directors meeting, all the 12 directors will be present in BOD meeting. Creditors meeting in terms of the insolvency. So creditors meeting during the insolvency. In terms of insolvency of the organization, this meeting will be usually conducted. Okay, so if an organization is insolvent, unable to repay the debts of the organization, okay, so meeting will be conducted. They are going to decide, okay, how the debts should be recovered, how they are going to preferably pay the debts. Okay, so these are all the things will be discussed in this terms of this meeting. Final meeting of dissolution. Dissolution is nothing but the liquidation. Liquidation meeting, that is a final meeting of the organization. It is a last meeting of the organization. In this last meeting, all the kinds of the stakeholders, shareholders, debenture holders, shareholders, all the people that they are going to call together, they are going to disclose about the liquidation of the organization, and also that they are going to disclose about how they are going to sell out the properties of the organization, how they are going to distribute the funds, when they are going to distribute the funds, all the things will be discussed here. Next one, importance of a company meeting. Why this company meeting is important? Okay, so proper decision making. This company meeting is important to take the relevant proper decisions, so that in meeting all the people can gather, discuss with each other, share their perspectives, opinions. Finally, they can come to a conclusion. It can become a valid meeting and they can take a valid decision. Okay, so that we call it as a proper decision making. So if we conduct a meeting, my perception is different when compared to other directors' perception. So if we discuss with each other, we can come for a conclusion. Okay, so that is the main motto of the meeting, proper decision making. I can make the relevant decision properly, optimistically, and also effectively. Followed by legal requirement. It is a legal requisite. Okay, so it is a kind of a legal requisite that is required under Companies Act 2013 to make a decisions, because there are 5 members in the organization or 5 directors in board. Okay, so only a single member cannot take the decision. He have to discuss with all these 5 members and finally they can take a decision. Okay, so that we call it as a legal requisite. It is conducted to maintain the legality and to maintain the transparency, and they must make sure that it has been conducted as per the convenience of Companies Act 2013, followed by they are supposed to mention in articles of the association. Transparency. To maintain transparency, they are going to conduct meeting. Okay, for example, if I want to make a decision as a director, I cannot talk with each and every individual director separately and make the decision. I need to call all the people together to convey the things and make the decision. So that it means that I am transparent. We people are maintaining transparent with each other. Even in terms of shareholders also. I cannot call a different group of shareholders and talk to them and take the decision. Directly, I'm going to call all the shareholders of the organization for the conduction of annual general meeting, so that all the financial statement will be disclosed. Okay, profit and losses, income and expenditure will be disclosed. Whatever the questions or the queries that the people have, we are ready to answer for their queries. Okay, so this is the actual protocol, how exactly the things should be happen. Okay, that we call it as a transparency. To maintain transparency, to say that I am genuine, okay, the meeting will be conducted. No kind of a malpractice is going to happen in my organization. Prove that they are going to conduct a meeting. Accountability and management. Accountability of management. This management is accountable for the shareholders. How they are accountable for the shareholders? Because they are invested on the company, right? Okay, so these people are accountable because in terms of annual general meeting, shareholders are going to ask the questions regarding the profits and losses of the organization, performance of the organization, accuracy and also profitability of the organization. These people are answerable. Okay, who? The management. The management is answerable for all the queries that is being asked by the shareholders. Protection of shareholders' right. This meeting give a right for the shareholders to clarify their doubts, to ask the question, to vote in terms of meeting. Okay, so it is going to uphold the rights of the shareholders. Followed by better communication. Okay, so instead of communicating the people separately, okay, so I can directly communicate while bringing all the people together in the name of meeting. Okay, that we call it as a better communication. Okay, the company secretary is responsible to communicate all the people regarding the meeting. Approval of major policies. If I want to approve any kind of the policies, voluntarily I cannot take the action. Okay, so I need to go with the permission of the people, relevant people, whether it is a board of directors, if it is needed, shareholders, stakeholders. Okay, so these are the things which is going to happen. Strengthening corporate governance. Okay, so we are going to conduct a meeting. We must make sure that my meeting is going to follow Companies Act 2013 in terms of conduction of meeting, quorum of the meeting, members who attend the meeting, in terms of notice. Okay, so and also it is going to follow the corporate governance. Role of company secretary in conduction of meetings. Okay, so if company is going to conduct a meeting, as I said you, company secretary is the responsible person for the conduction of meeting. Notice preparation. Company secretary is responsible for the preparation of notice when it comes in terms of a company meeting. Okay, so as I said you, before conduction of meeting, the company secretary is responsible to send the notification or the notice to the people, to the shareholders, to the directors of the organization. Done? Okay. So he's responsible. Company secretary is responsible to send the notice for the relevant people to attend the meeting 21 days priorly. Okay, 21 days early. In this notice, all the things is being disclosed. Say for example, we are going to conduct an annual general meeting. I am going to send a notice 21 days priorly for all the shareholders, for all the directors, for all the top management people, saying that we are conducting annual general meeting on so and so date. Date should be mentioned specifically, time should be mentioned, venue should be mentioned. Okay, what is the agenda of that particular meeting will be mentioned. Okay, so in terms of annual general meeting also, they are going to disclose the financial statement with the notice. Okay, so all the things should be taken care by the company secretary. It is his responsibility. Agenda setting, he is the responsible person to set the agenda. If we have to consider a meeting as a valid meeting, there must be agenda for meeting. Without knowing what we are going to, for what reason we are going to gather, what topics that we are going to discuss, we won't conduct any kind of meeting. If we are going to conduct a meeting, there is a separate agenda will be prepared, which are the topics which should be discussed in the meeting. Okay, so he's the person who is going to take care of venue and logistic. Okay, so when it comes in terms of a notice, he have to specifically mention, okay, the venue and also the requirements that is required for the valid meeting. For example, we had conducted a board of directors meeting, okay, in a resort. Let me say it is a resort. Which are all the requisites that is required? If there is any kind of a voting required, okay, we need to prepare our ballot papers, proper arrangement of seats of board of directors, and also the facilities or basic facilities like snacks, lunch or dinner and whatever it is. Okay, the mics that is required to speak, to convey. Okay, so these are all the arrangements will be taken care by the company secretary. Record keeping. So record keeping plays a vital role when it comes in terms of company meeting. So he is responsible person who used to keep all the records starting from the financial statement, starting from the notice till the people one who had agreed for to come for a meeting, the people one who had came for a meeting, which are the topics that had been discussed, what is the agenda of the session, minutes of meeting, whether we are going to implement the decision that had been taken by the meeting. It is the responsibility of the company secretary. He is the responsible person to keep all these records. Okay, starting from, okay, so notice till the implementation, he is going to keep the complete record. Legal compliance. So he have to make sure that the conduction of the meeting is as per Companies Act 2013. The way how they are going to convey the notice to the people, the way how the people are going to attend the quorum of the meeting, followed by the minutes of meeting and the outcomes of the meeting, all should be as per the corporate governance followed by a Companies Act 2013 and should be mentioned in articles of the association according to Companies Act 2013. Communication. It is his responsibility to communicate the people, to communicate the management, to communicate the shareholders, board of directors, shareholders. Okay, so regarding the meeting. Follow-up action. So not only making decision in the meeting is important, but looking that whether the decision is being implemented or no, it is more important. They are supposed to implement the decision as per their decision. Okay, so he is the one who is going to look over the decisions of the organization that is being decided in the company meeting. Proxy management. What is proxy? For example, Mr. A is a shareholder of XYZ Company Limited. For certain reasons, he couldn't able to attend the annual general meeting. Okay, so in his place, he can send Mr. B to attend the annual general meeting for the company. I repeat, so A couldn't able to attend annual general meeting being a shareholder of the organization. He can replace Mr. B in his place to attend annual general meeting. And this B will be having a complete authority to attend the meeting by filling the proxy form that is been given by the organization. Okay, it is a consent form saying that A couldn't able to attend the meeting. He have all the permission to attend the meeting to the B. By filling the proxy form, B can attend annual general meeting in the place of A. It is a kind of a declaration given by Mr. A, saying that Mr. B having all the right to attend the annual general meeting in my place, in my name. Okay, so he will be having all the right to attend the meeting, and also he will be having all the right to vote in meeting in terms of any kind of elections that has been conducted in the annual general meeting. Okay, so that we call it as a proxy. Okay, so in his place he can attend the meeting. Duplicate person. Advisory role. Okay, so this company secretary also plays a advisory role when it comes in terms of a organization. He's going to advise the managing directors, he's going to advise board of directors, he's going to advise the top level management. Okay, so he's responsible. The next session we are going with requisites of a valid meeting. So which are the required elements should be present to consider the meeting as a valid meeting, followed by notice. So these are the requisites of a valid meeting: notice, quorum, resolution, voting, and proxy. So these are the topic that we are going to discuss in the next session. Thank you.